What's up? Welcome to the courtroom.
I am Theo.
And I'm Oj. And in this podcast, we tell you stories about people's life, liberty, and property.
Kikwentuhan namin kayo about court rulings in a way that will make you understand jurisprudence like a 9-year-old.
All persons before the Honorable Supreme Court of the Philippines shall give their attention for the court now in session.
So join us as we delve into true crime, political controversies, and all things tare de chismis every week.
The National Power Corporation, or Napocor, is a government-owned and controlled corporation that is mandated to develop and produce electricity and transmit electric power nationwide.
Isa ang mga residente ng Cabanatuan City sa mga nagkukonsumo ng kuryente mula sa Napocor. And in 1992, nakapagtala ng gross income ang Napocor ng 107 million plus. Hindi ko na sabihin yung exact mula sa Cabanatuan City.
And pursuant to Section 37 of the City Ordinance No. 165-92, Cabanatuan City assessed a franchise tax amounting to around 800,000.
Oh, laki ah.
Actually, that only represents 75% ng 1% gross receipt ng Napocor for the preceding year.
Well, I guess it doesn't matter if malaki or maliit yan because just the same, Napocor refuses to pay the tax assessed on the ground na wala daw authority ang City of Cabanatuan to impose tax on government entities and that exempted daw sila from paying all forms of taxes, charges, duties, and fees in accordance to Section 13 of the Revised Charter of Napocor or RA 6395.
Ano ba nakalagay sa Section 13? Ba't sila exempted?
Nakalagay doon that non-profit organizations are exempted from all tax, duties, fees, imposed and other charges by government and governmental instrumentalities. Non-profit daw sila kasi pinapaikot lang naman nila yung revenues nila to its operation and expansion.
Siyempre, the City of Cabanatuan aptly filed a collection suit in RTC demanding Napocor to pay the assessed tax due. Sabi nila, yung sinasabing exemption ng Napocor from local taxes has actually been repealed already by Section 193 of RA 7160 of the Local Government Code or LGC.
In summary, ano bang sabi sa Section 193 of LGC?
Well, Section 193 states na yung mga tax exemptions or incentives granted to or presently enjoyed by all persons, whether natural or juridical, kasama na yung government-owned and controlled corporations are hereby withdrawn o wala nang bisa upon the effectivity of this code.
So, lahat ng government-owned or controlled corporation or GOCC kasi ang haba nun, pasok dito.
Actually, hindi. Section 193 provides an exception to local water districts, cooperatives duly registered under RA number 6938, non-stock and non-profit hospitals and educational institutions. If maaalala mo sa StatCon, Teo, the express mention of one person, thing, act, or consequence excludes all others.
Naalala ko yan. May maxim yan eh. Yung expressio unius e exclusio alterius. Yun yung Latin maxim. Pero in layman's term, for short, if di ka nabanggit sa mga exceptions, then hindi ka talaga kasama. Intended na hindi ka talaga kasama.
Yon. And despite this point by the City of Cabanatuan, the trial court proceeded to dismiss the case. They cited the ruling in the case of Basco versus Pagcor, kung saan the Supreme Court said that local governments have no power to tax instrumentalities of the national government. With Pagcor being a GOCC and instrumentality of the government, Pagcor should be and actually is exempt from local taxes. Otherwise, its operation might be burdened, impeded, or subjected to control by mere local government.
As expected, the City of Cabanatuan appealed the case and this time, the CA reversed the trial court's order on the ground nga that pertinent provisions of the local government code such as Section 193, 136, and 151 expressly withdraws the exemption previously granted to Napocor.
Napocor then filed a motion for reconsideration on the Court of Appeals decision. Kaso, this was also denied.
Ano nga bang arguments ng Napocor in their MR?
Sabi kasi nila, yung taxing power daw of the province under Article 137 of the Local Government Code refers merely to private persons or corporations in which Napocor does not belong. Tsaka yung Local Government Code daw is a general law. So, it may not impliedly repeal the charter of Napocor, which is a special law.
Okay, dahil denied ang MR nila, Napocor filed a petition for review to the Supreme Court. Ngayon, sasagutin ng Supreme Court if yung exemption ba ng Napocor has been repealed by the LGC since mas latest enactment to.
At sasagutin din ng court if Napocor, a public non-profit corporation, is liable ba to pay franchise tax since Section 137 of LGC in relation to Section 131 applied only to private persons or corporations enjoying a franchise.
Well, unahin na natin yung franchise tax mo. Una, wala namang question that the city government has the authority to issue Ordinance number 16592 and eventually impose an annual tax on businesses enjoying a franchise pursuant to the local government code. So, ang kailangan lang natin dito i-quantify if pasok nga ba yung Napocor sa mga pwedeng patawan ng franchise tax.
According to the Supreme Court, Section 151 in relation to Section 137 of the Local Government Code clearly states that the city may levy taxes, fees, and charges which the province or municipality may impose.
Dinedefine din ng court kung ano at para saan ba tong franchise na tinatawag. Pero naalala ko ABS-CBN pag sinasabing franchise. Anyhow, according to the court, a franchise is a privilege conferred by the government authority. So, a franchise may refer to a general or primary franchise or to second category which is a special or secondary franchise. So, ano ba yung difference niyang primary at secondary?
Yung general or primary franchise relates to the right to exist as a corporation. This right is vested upon the individuals who compose the corporation and not in the corporation itself. While yung special or secondary franchise naman is conferred dun sa mga corporation na existing na and referred to, for example, the right to use streets para magkabit ng kable ng kuryente. This right naman is vested to the corporation.
Yan, well explained, Oj. So, sa Section 131 ng Local Government Code, yung franchise na binabanggit is actually of the secondary or special franchise. So, in retrospect, a franchise tax is a tax on the privilege of transacting business in the state and exercising corporate franchises granted by the state.
May two requisites para malaman natin if covered ba ang Napocor ng franchise tax. First, does the petitioner have a franchise in the sense of a secondary or special franchise?
The answer is yes. Commonwealth Act number 120 as amended by RA 7395 vests Napocor the power which are not available actually to ordinary corporations. So yes, they are under the concept of the secondary or special franchise. Ano yung second requirement?
Okay, now, for the second requisite, does the petitioner exercise its rights or privileges under this franchise within the territory of the respondent city government?
The answer is yes again, syempre. Napocor is operating within the Cabanatuan City Government's territorial jurisdiction at dahil nga pasok siya sa banga at nabingo niya yung both requisites, Napocor is and ought to be subject of the franchise tax in question.
Naalala mo, Teo, Napocor cited the doctrine in Basco versus Philippine Amusement and Gaming Corporation, where this court held that local governments have no power to tax instrumentalities of the national government, such as PAGCOR, and in this case, Napocor.
Yeah, kasi that doctrine emanates from the supremacy of the national government over local governments.
Although, the court said that this ruling no longer applies since the Basco case was decided prior to the effectivity of the LGC, when no law empowering the local government units to tax instrumentalities of the national government was in effect.
Nagkaroon kasi ng paradigm shift, Oj, from supremacy of the national government to a decentralization of governance and strengthening of the local autonomy. Yung rationale nito is to shatter this culture of dependence sa national leadership. Siyempre, by giving local government unit as a wider role and sufficient power to generate their own source of income.
Article 10, Section 5 of the 1987 Constitution actually provides that the power to tax is no longer vested exclusively on Congress. Local legislative bodies are now given direct authority to levy taxes, fees, and other charges.
Aside from that, Oj, Section 3 of Article 10 of the 1987 Constitution mandates Congress to enact a local government code that will, consistent with the basic policy of local autonomy, will set the guidelines and limitation to this grant of taxing powers.
Dahil nga sa constitutional mandate na to, nabuo ang Local Government Code, which is considered the most revolutionary piece of legislation on local autonomy. One of the most significant provisions of the LGC is the removal of the blanket exclusion of instrumentalities and agencies of the national government from the coverage of local taxation.
Although, a general rule is that LGUs cannot impose taxes of any kind on the national government, its instrumentalities and agencies. This rule now admits an exemption kasi may specific provision sa LGC that authorize LGU actually to impose tax.
As this court ruled in the case of Mactan Cebu International Airport Authority versus Marcos, even instrumentalities or agencies of the government performing governmental functions may now be taxed.
Isa pa pala sa ini-insist ng Napocor is that excluded daw sila sa franchise tax kasi its tax are wholly owned by the national government and its charter characterized it as a non-profit organization.
Sabi ng court, a franchise tax is imposed based not on the ownership but on the exercise by the corporation of a privilege to do business. Section 2 of PD number 202-963 classifies GOCCs into those performing governmental functions and those performing proprietary functions.
Napocor belongs to those performing proprietary functions since yung task nila of generating power and selling electricity in bulk certainly does not partake sovereign function. Kahit ba sabihin they are for public interest, there are still purely private and commercial undertakings.
Then yung contention ng Napocor na its tax exemptions under its charter still prevails despite the passage of the LGC also fail kasi as a rule, tax exemptions are construed strongly against the claimant. Kung may exemptions man, it must be shown to exist clearly and categorically and supported by clear legal provisions.
Wala naman na sigurong mas lilinaw pa that Section 193 of the LGC withdraws, subject to limited exception, the sweeping tax privilege previously enjoyed by private and public corporations such as Napocor. Even if it is a general law, Section 193 of the LGC is an express repeal of all statutes granting tax exemption from local taxes.
And let's say, meron ng provision sa LGC that says na exempted sila sa local taxes. It would still be futile since Section 137 of the LGC clearly states that LGUs can impose franchise tax notwithstanding any exemption granted by any law or other special law. So, wala talaga silang takas.
Ika nga, taxes are the lifeblood of the government. For without taxes, the government can neither exist nor endure.
Yung fury behind the exercise of the power to tax emanates from necessity. Kasi, syempre, without taxes, government cannot fulfill its mandate of promoting the general welfare and well-being of the people.
Habang dumadami ang social challenges and state activity, taxation has become a tool to realize social justice at para magkaroon ng equitable distribution of wealth, economic progress, and the protection of local industries as well as public welfare and other similar objectives.
The power to tax is the most effective instrument to raise needed revenues to finance and support myriad activities of the local government units for the delivery of basic services essential to the promotion of the general welfare and the enhancement of peace, progress, and prosperity of the people.
With the added burden of devolution, it is more imperative para sa government entities para magbigay ng kanilang ambag in the requirements of development, fiscal or otherwise, by paying taxes or other charges due to them. I mean, hindi ba mas magandang maging mabuting halimbawa yung gobyerno about paying taxes?
Kaya naman sa case na to, the Supreme Court denied the petition for review ng Napocor and assailed the decision and resolution of the Court of Appeals, ordering Napocor to pay Cabanatuan City Government the sum of 800,000 pesos plus representing the franchise tax due based on gross receipts for the year 1992.
They also ordered Napocor to pay the tax due every year thereafter based on the gross receipt earned by NPC, and in all cases to pay the surcharge of 25% of the tax due and unpaid and the sum of 10,000 pesos as litigation expenses.
If you guys like this audiogram, please listen to the full episode on Spotify or on your favorite podcast app, where you can hear our insights on this case. Again, this is Oj.
And Theo, leaving you with a reminder to always look back in history because precedent shall rule the future.
Thank you for listening, and we'll see you again in the courtroom.
Bye!